Howdy, folks. Matt Price here. I just got done taking my best friend and his wife or they're coming back from the airport from their week-long vacation with their son and son-in-law. And I was thinking on the way there that him and I have been pretty much brothers ever since we knew, before went into puberty. So 40, 42, 43 years ago. Um, it's weird because we've known each other. We known each other's tricks, tips, everything about us. In fact, we probably know more about each other than our wives do. And that's all fine because it's not necessarily the secrets and all the things and all the bad stuff that we did when we were a kid that's a problem. The problem is that I have actual blood family that treats me worse than he does. And that's the common thing is that he treats me like I'm truly a brother, and I treat him like he's truly a brother. And what becomes of it is we've not had we've had our arguments a couple of times, but over the last several years, even he says, your family's crazy, and I said, watch it there, buddy, you're my brother. That's funny, isn't it? So anyway, the funny thing about it is that when I took him to the airport, it was just a regular drop off, get him on the plane, and then drive home, make sure everything's okay. And then today was to pick him up and bring him back to my house, and then he dropped me off, and then he moved on about his business to his house. But it's funny that there are some families out there where there's a lot of jealousy, there's a lot of disgust, there's a lot of vile that goes on, and then there are some families where they just bond together and they show that there is hope for humanity in a family setting than most people, and this is something that I always put into my kids is that love your brothers because one of these days you're going to need them. And love your brothers because you may not be able to do something they can, right? So there's always this continual thing that I try to build up on all these levels is your brothers are your best friends, your wives are your bester friends. So I got 2 out of 3 that are married, and the last one is getting ready to pop the question. So I am ecstatic that I finally get rid of all of them out of the house. That's a plus, right? Well, it seems like in some cases you never get rid of your brother or sister who sit here in your house and they think that they're entitled to everything that you own. And I'll talk about that a little bit more. But the thing that concerns me more than anything else when anything goes to probate is these family struggles that go on. And I don't know if it makes any logical sense. But here it goes. Let's try it. When a family runs into conflict over how real estate or personal property or anything is handled in the estate, if the solution can't be that they sit down at the table and they have that discussion and make a straightforward plan in order to do what they need to do, it can become extremely expensive. And what I mean by that is once it passes an impasse, then the courts make the decision. And when it hits the courts very hard. Because now, and what we're talking about is the court. The court is not cheap. The court does not care if you think it's expensive or not. But I digress. So let's talk about it a little bit more in depth. When a family runs into conflict over how real estate is handled in an estate, the solution can be straightforward, as I said before, or it can be extremely expensive. That's because in North Carolina, a real estate broker can facilitate a sale, but they cannot fix title problems. We cannot override the heirs. We cannot force signatures. The law, not family preferences, controls what happens. And I get a lot of people who are ticked off at the executor who call me saying, I want this house sold at auction. Can you do it for me? And I'm like, absolutely. Are you the executor? Well, no, my sister is, but I don't think she's handling it appropriately. Well, have your sister call me, because I can't talk to anybody else. I can only talk to the executor. So that is one thing where something has completely fallen off the rails. So to understand why these situations get complicated quickly, it's not that difficult. We need to establish a few fundamental definitions. First, intestate means they've died without a valid will. The document is saved on a computer, unsigned, unwitnessed, unnotarized. It's not a legal will under North Carolina. It has to be proved. The state requires proper execution for a will to have any kind of authority. Second, the North Carolina Intestate Succession Act determines who inherits the property when someone passes away without a will. Under this law, the title to real property vests immediately in the heirs at the moment of death, which means mom and dad passed away. They have 4 heirs or 4 siblings or 4 children. All 4 of them own the property. They have equal, undivided rights to the property. What do I mean by that? If JJ decides that he's going to go down there and hunt on the land, he's perfectly capable of doing so, rent-free. If Frank decides he's going to go down there and he's going to live in the property, that's perfectly fine. He can do that, rent-free, because he's an owner of the property. If Ted decides that he's going to go down there and he's going to build a lemonade stand, he can do that. If Sarah decides that she doesn't want anything to do with it, and whatever, it's perfectly fine. She can do that. 9 times out of 10 is when they get that bill for the taxes and the assessments and everything else, is when all of a sudden everybody cares about it. Under the law, the title of real property vests immediately in the heirs, which means all the responsibilities vest immediately in those heirs at the moment of death. Not, oh, well, we recorded the will. It's at the moment of death. I've had fights with attorneys who did not know real estate law, who were telling me that's not the case, and they lost because they did not understand what they were saying. And they refused to go back and take a look at any of the North Carolina laws. And I asked one of them, point blank in his face, if you don't know the law, why are you practicing? He got extremely mad at me, and I reported him for ethics and malpractice. And I'm not ashamed of it. Some people say, oh, well, you know, just because he's mishandled. If he's mishandling one case, he's mishandling several others, right? Because it's not something that just happens overnight. They're just litigators, and that's all they do is litigate. Oh, well, that's not really what the law says. The law says this, that, and the other. Well, North Carolina, the law is generically specific enough where he is full of it. And he knows who he is, because I know he's watching. So I digress. So when a person does die intestate with a valid will, or does die testate with a valid will, the executor must carry out the instructions exactly as written in the will. North Carolina governs every step of that process. So when somebody says, you're not doing what the will says, there's a 100% chance that, 1, they never read the will. 2, they're trying to interpret the words in the will according to what they want, not what is required. And I'm sorry, but even when siblings disagree, the executor cannot deviate from the last will and testament's terms. If the last will and testament does not say give blank $20,000, they don't get $20,000. If it says if it does not say give blank all the guns, they don't get the guns. If it says give blank the house, they don't get the house. They cannot deviate from the last will and testament. But when the real estate is involved, the situation can become more complicated with or without a will. And only because it gets, in some cases, kind of hairy. I mean, let's face it. Whether you like it or hate it, the 250th anniversary or celebration of the United States of America is going to happen whether people like it or not. I just got a notification on my phone saying that somebody decided that they were going to sue because they did not like that the aesthetics of the UFC ring outside of the White House. So yes, there is that level of issue inside of probate, and there are plenty of attorneys who will chase that down and say, hey, jump right on it and run right with it, right? And every single time that happens, it costs the estate. It costs the estate a lot of money. It's not cheap. And that's one of the things that I keep telling people. It's like, it can be a smooth process or it can be expensive. It's really up to you. It's really up to them. So let me give you a specific example. Frank Robin Sue and Brenda's parents pass away, and the will does not specifically say what to do with the real estate. It does not specifically direct what happens to the real estate. And they really haven't even said anything inside of the will what should happen to the real estate. Well, under North Carolina law, when a will is silent on the real property or when there is no will, it passes automatically to the heirs as tenants in common. Get that attorney with the ethics violation? Let me say it again, just in case you missed it. Okay? Pardon my sarcasm, but you really ticked me off. Under North Carolina law, when the will is silent on real property, that means it says we give the person authorization to sell it, or it does not say a word. Then it goes to all of the heirs as tenants in common. If the will says we grant the authority to the executor to sell it, it still needs 4 signatures. Don't sue people because you know better. You're just costing money so you can... My favorite is when they go, hey, you're enriching yourself. You realize that attorneys will sue for frivolous reasons to enrich themselves, right, folks? If they don't know the law, then they will sue because they don't understand the property rights in North Carolina. And to me, that should get them disqualified to practice law. Think about it. If you hire a car mechanic and he doesn't know how to fix a car, what the hell are you doing with the car mechanic? Plain simple. So most of you don't understand what tenants in common mean, and so let's go through it. Tenants in common is each own an undivided share of an entire property. There's no right of survivorship. If one owner dies, their share passes to their kids and not to the other co-owners. That's not how that works. And each owner has a full use and enjoyment of the entire property, but no single owner can force another to pay rent or surrender their rights. Attorney! You sued a person because you demanded rent for something that was tenants in common. Yeah. Believe you me, ladies and gentlemen, there are those out there. If owner A dies, then the share goes to their children. The only way owner B can gain full ownership is by purchasing the other shares. In other words, buying out the others. And if the others don't want to sell, maybe their children will. You never know. For in this example, Frank is named executor, but the will does not give him authority to sell the real estate. Therefore, at the moment of death, the 4 siblings, Frank, Bob, Sue, and Brenda, become tenants in common. Even if the will gave him authority to sell the real estate, he still needs 4 signatures. The authority to sell the real estate is not the authority to sell tenants in the entirety or ownership of being able to do so. And I argued this in court, and the judge said, that makes sense. Just because somebody gives you the authority to drive their car don't mean they own it. See what I'm saying? So, an attempt to sell. So, Sue hires a real estate broker without telling the others, which is a no-no. But one tenant in common cannot sell the entire property. All the co-owners must agree and list and sell. All 4 signatures. See what I'm saying here? Eventually, all 4 agree to list the property, and the offer comes in, but Frank's wife refuses to sign because she does not want Bob to receive any money. Good luck, that's not going to happen. Her refusal has no legal basis, but still blocks the sale. At closing, proceeds must be distributed according to the ownership interest. No spouse can veto that. In other words, 4 signatures, spouse can complain all they want. Don't matter. This kind of emotional interference can escalate into a very costly litigation problem, costing tens or hundreds of thousands of dollars. And I can tell you the story of our estate, and you people are going to go. So, for an example, when a partition action becomes necessary, assume the property is worth $200,000, and they receive a offer for $350,000. Frank's wife still refuses to sign. Brenda, who lives 9 hours away and don't want to keep paying taxes on the land it cannot use, hires an attorney, and the attorney files a petition to partition. And in North Carolina, that means forcing the sale. A partition action asks the court to force the sale of the property, and the court appoints a commissioner. Ka-ching! The property is then sold, often literally on the courthouse steps. So you're talking about an attorney, their agents, or their professional assistants, clerks, recording, court costs, you name it. Everything at this point in time costs money. If you call up the clerk and say, hey, I have a letter, you send that letter in. That letter gets put into the file, recorded, and guess what happens when they put their little stampy on it? The estate owes the court money. Go figure. So the harsh reality about petition sales, because a lot of people think that this can't happen, and I'm being God honest with you, and everybody says, well, this is not professional behavior, and it is professional behavior, because I'm telling you and I'm showing you what the frustration is. The frustration level of doing it wrong is more than the frustration level of doing it right. The frustration level of doing everything back-asswards causes immense amount of problems, and I'll explain to it at the end of this. So a partition action goes through the court. Court says, okay, sell it. And the harsh reality is court-ordered sales rarely bring market value. When I mean rarely, never. Hardly ever. Properties commonly sell for a fraction of their worth. Sometimes around 10 cents on the dollar, sometimes all the way down to a penny on a dollar, because investors dominate courthouses. They dominate the courthouse step auctions. Period. The court doesn't care who it gets sold to as long as it gets sold in order to quiet the complaint. Once the commissioner sells the property, the owners have no recourse. Period. Can't complain about it. If a $200,000 property sells for $10,000, that's $10,000 minus the court costs and all the fees, including the commissioner. That's all that all remains to divide. So Brenda might walk away with $1,000, but at least the dispute is over. And guess what? Frank still gets money. The difference between the two outcomes. This is the big thing. And a lot of people say, well, why don't you just sit down and say this? Well, I am right now, online, talking to you, telling you what's going on. When all the co-owners cooperate, the property sells at market value and everyone receives their fair share. When a partition action is filed, the family loses the equity, they lose control, loses tens of hundreds of thousands of dollars in value, and the court's sale is final, and the financial loss is permanent, and you cannot contest it. So a $250,000 property in which you take the $250 and you take a $250,000 property, divide it by 4. That was $50,000 a piece. $25,000. Well, $200,000. That's $50,000 a piece. And then a chunk of the $50,000 divided by 4. That's a little over $12,500. Now you get $1,000. And we can go deeply, deeply, deeply into this. But the fact of the matter is that it can seriously cause a lot of damage. And when I mean it seriously can cost you a lot of damage, let me give you an example. So both of my parents died. And my father passed away in 2016. My mother passed away in 2018. I was the executor of the will. The will was signed, but it wasn't notarized by the bank. So I had to go get it proofed by the people who signed it. And tracking them down was not so much as a pain in the rump as most people would say, but I had to send them a copy of the will, and I had to send them a sheet for them to sign and say, yes, that is my signature, and then notarize, and then send it back to me in order for it to go back to the clerk of court, who would put it down, and that was what's in will. If I did not do that, I just take that will and throw it away, because even though their intentions were written down, without it being proofed, 2 signatures and a notary, it was just as useless as if they didn't write one at all. So I went through all of that. Cost money. Then I went and got sworn in as the executor. In almost the second week of being sworn in as the executor, I get sued by this moron attorney who says, well, we don't think you're doing anything right. Oh, really? Okay. Well, let's play along. So anyway, he wanted me to run all over the county asking for this document, this paperwork, and whatnot. And finally, I said, you know what? I'm done with this. So I hired my attorney, and I told them they're not getting any more documentation from me. They have to prove it. I'm not going to give them the documentation. I'm not going to shoot myself in the foot for them. Comes in mediation. Mediation, if you think it's cheap, it ain't. So we had the real estate, we had the bank accounts, we had the insurance stuff. All that money went to them automatically after I presented to them with the change of address for each one of the people, and also the all that other stuff. They seem to have thought that my parents, only making $28,000 a year, had assets of $4.5 million somewhere in there. Of course, their attorney can't read. And because he can't read, he did not see that there was nothing close to that. So like I said, this guy's a moron. And I'm happy to say that. And if you bring legal action, I'll be happy to prove it. So anyway, got to mediation. And they wanted $1.6 million apiece. They wanted $800,000, which was still $500,000 more than was in the estate. After they got all said and all done, they settled. I didn't take the piece of that settlement because I was the one being sued. All said and done, that ate up $200,000. They got paid $25,000 each, in which, to this day, the siblings who sued me have not seen a penny because the attorney's fees for their actions was more than that. They still owe the attorney who sued me. But I won in court. Now, when they got done with mediation, and when they got done with mediation, I have never seen an attorney get up, haul ass faster in my life. Because this guy knew what was coming. And it was a tornado of hell. Because he was an incompetent, negligent, malpractice-filled jerk. And he knew it was going to be parking lot time. Because he screwed our family out of money because he refused to understand the law and tell them, well, he's doing everything right. According to this, there's no impropriety here. He assumed that there was an impropriety without verifying a freaking thing. So, if you're going to sue because of this, I want you to understand. Or if you're going to do a partition because of this, I want you to understand. I wanted to get it into your head. And if you have a sister, brother, whatever sibling who thinks that Cuckoo for Cocoa Puffs is brilliant, send them this video. Because you could easily take your profit on a house that has a mortgage. You have $200,000 and your mortgage is $100,000. If you sue for a partition to petition, they may give $50,000. And guess what? The estate owes the difference. What they can get is zero. Absolute zero. So we want to make sure that people understand that when you are in probate, there are certain things that you can do and certain things you don't, and it's completely court supervised. So whatever happens, your documentation, your inventories, all of that has to go up to the court, and then they record it and they review it before they close out the documentation. So if you're going to hire an estate attorney, go to the North Carolina bar and find somebody who is certified as a certified estate attorney. Not somebody who is a litigator who says, oh, well, I handle estates. No, you, Matlock, handle criminal, civil things. The only thing that you do is you just make money for your firm. Or you make money for yourself and you give for your firm a little bit of money. Anyway, folks, if you get a chance, read the article that I have on my website. It's ebbids.com. And it is out there, and it says, probate real estate can be easy or it can be hard. And I want you to go through and take a look at that because it has a lot of things in it that I cannot express here. Such as tenants, ownership interests, those kind of things. It also goes into explaining tenants in an apartment, etc. So anyway, I'm Matt Price. If you need me, give me a call, 919-614-6288. I'm not doing anything flashy that all these other real estate brokers do. because I have seen the level of professionalism of some of these real estate brokers, and I wouldn't even trust them babysitting my dog. A lot of these people are brought in, they're given a license, and they really don't know how to sell anything on Craigslist. I mean, they can't sell a remote control on Craigslist. I mean, it's absolutely insane. And the attorneys are absolutely crazy too. But anyway, be kind, be bountiful, be blessed. Have a great week.